There's really nothing groundbreaking about it. The answers were already there from the onset. What the court did, first of all, we must say it was a unanimous judgment. And when you say unanimous, means that all the judges agree that one of the prayers that was put before the court was unsustainable. And that prayer was that the people had gone to court to ask the court to compel the speaker to come with a motion to have a secret ballot in terms of dealing with this motion. So the court rejected that. So that's very important. And then the court went to put in a number of principles that should guide the speaker. The first principle that the court talked about is that is respect for the constitutional pillars. And those pillars come in the form of separation of powers, that the court cannot be expected to take over the business of running parliament. So that's why the court says we are not going to instruct the speaker. But what we are going to do, we are going to explain to the speaker what is called the constitutional principle. And the principle is that the Constitution has not expressed itself on the matter of voting, whether by secret or open. But there are guidelines that we can take from there. But the first thing on that is that the Speaker's understanding was incorrect when she said she is not empowered to order a secret ballot. But what the court was saying to say, Madam Speaker, you are incorrect here. That is up to you. So effectively the court went back to her that says that provision is within your constitutionally given discretion. So right now the matter will then go to the speaker. But there's also another element that the court said, which is also important, that our constitution is also based on a party system. And within the party system, you also have a constitutional principle and value of transparency. And the court did not buy the idea that people will be intimidated. It says sometimes standing for what you believe in.
I'm very sorry, Professor. We're going to have to just interrupt you. We have a reaction coming in live now from outside the conCourt.
And it's a groundbreaking judgment because it has now indicated that the Speaker has the power, whenever she considers it appropriate, or when she is appealed to by members of the National Assembly or the National Council of Provinces, asking for protection so that they can vote with clear consciences and without fear of reprisals. It's not been done before. It means that from this point onwards, the speakers, the presiding officers of our two houses of parliament, even in the legislatures, even in the local government, everywhere, they will be able now to exercise this secret ballot thing whenever they are approached and asked to do so by members of their legislatures.
And do you believe that, do you have confidence in her and thinking that she will make the correct decision? As we now know, according to the court judgment, it is completely up to her to make the decision of whether or not it will be a secret ballot or not.
She will be, because as you know, there are a number of ministers who already announced that they were threatened with death. There are statements which have been issued by the chief whip of the ruling party, compelling members of the legislature, of the caucus of the ANC, to vote for Zuma, even though Zuma has been found by this constitutional court to have broken his oath of office.
And going forward, how soon do you think we can expect the vote of no confidence, and what is your next step?
That unfortunately is really in the hands of the Speaker. I think next week Parliament will go into recess. It may well be that she will put it back to even after we come back from recess. I don't know.
We heard a few weeks ago the Secretary General of the ANC saying that members of the party must put away their own personal decisions and vote according to the parties and stand together according to the party's policy and directive. Do you believe that this will be one of the things that convinces her to perhaps allow a secret ballot?
Well, Mr. Mantashe clearly doesn't know how what the Constitution is about. The oath of office that all of us take says, I swear loyalty to the Republic of South Africa. Your loyalty, your oath of office says you swear to be loyal to the Republic, which means to be loyal to the Constitution. You can't now come and say the party is above the country. This is a theory that Zuma has been teaching all of them. And I don't know how long I've been telling them. There's no way that a political party can be above the country. There's no political party that can have a constitution that is above the Constitution of the Republic of South Africa. But he has persisted with that. But once again, the Chief Justice clarified it in this judgment. He says, once the members of the legislature take the oath to uphold the Constitution of the country, forget about the Constitution of the ANC or of COPE or of the DA or of the IFP. It's nothing.
Thank you.
Well, that was a reaction coming in from the COURT leader, Lekota, just from outside the Constitutional Court. We will now go back to Professor Sipho Seepe, joining me in a studio from the newsroom. Well, Professor Sipho, do you think that now that the Speaker actually does have the say, do you not think that this puts her in a precarious position, actually, that she has to make the decision now and that she will be in the spotlight as the one as to who said, is it going to be a secret ballot vote or is it going to be an open ballot?
Well, I think it doesn't, because that power was always there. It also reflects on the weakness of the legal advice that she was getting. But if you remember in court, when the issue was raised, her own counsel accepted that the Constitution has not expressed itself either way. And therefore, you cannot say, I am prevented by the Constitution from doing certain things when the Constitution has not done so. So that is the first thing. And what the court did was simply to reaffirm that power of discretion that lies in the office. So that is the first thing that we must deal with. So the excitement about groundbreaking, it's actually nonsense. The Speaker always had that what the court did was simply to clarify that, and she herself has never said, she just sought clarity. But her own lawyer and own counsel was very clear that she has not been prevented. So we park that aside. Then we go back to what the court says, because the celebration that we see is actually misguided. It shows that the people did not even understand some of the guidance that came from the court. The court was very clear that the principle of transparency is one of the core values and principles in this country. That if the Chief Justice even went further to say, it cannot be correct to suggest that people should be voting in a cover of darkness. So the whole notion of the cover of darkness in itself reflects the notion of dishonesty. And the Chief Justice did talk about the issue of dishonesty among members of Parliament. And also, he was also alive to the fact that you could also have monies that are moving around where people can be bought. So effectively, the Speaker is being told that be aware of these things. But most importantly, the Chief Justice went further to say, we reaffirm that we are in a multi-party system and that there is the issue of a majority and a ruling party, that it has its own dictates. And the people are the best people to judge whether the Parliament, whether the members of a party have behaved well. And he says the best test is through general elections. So what the opposition parties are excited about is not derived from the judgment. Actually, they have chosen to misunderstand the judgment. The judgment simply says, well, you are correct to bring it to us, hence we're going to accord the cost to the other party. But most importantly, we are also guiding the Speaker that this Nicodemus approaches to decision-making is not good for democracy. Transparency is number one. And secondly, he says, it is also important that when people believe in something, they must have the courage of their views. They must not be driven by their comforts. So he was not persuaded by those who claim that they are intimidated. In fact, he was simply saying part of leading the people and representing them will require that level of courage.